My first emotion was absolute shock. It's like, say what? She's where?
I felt really anxious, like whatever is going to happen to me, can it just hurry up and happen?
What happened? What have I done as a parent? And so there's this feelings of guilt.
Panic. That's what I felt like. Panic.
I had to see her. I had to know that she was okay.
You feel helpless because you don't know what you're doing.
The first morning I came into the court I was scared, lost, a whole room full of people, and I felt all by myself.
Going through the juvenile court can be confusing and even scary, but you can get through it successfully. This video will introduce you to the basic juvenile offender process. An offender matter is when a youth is being charged with a criminal offense. The juvenile court is a relatively new concept. The first juvenile court was established just over 100 years ago in Illinois. Prior to this, youth over the age of 7 were tried just like adults and sent to adult prisons. In 1967, the Supreme Court decided that youth are entitled to some key elements of a fair trial, including getting notified of the charges against them, a right to have a lawyer, the right against self-incrimination, and the right to confront and cross-examine witnesses. However, juvenile courts are still different from adult courts in that youth in juvenile court do not receive a trial by jury. Judges still decide the outcome of a case. This and the fact that the court system recognizes that the youth are still learning and can be rehabilitated is the reason why juvenile courts still exist. When learning about the juvenile offender process, it is helpful to know all the people involved. The youth will meet with their defense attorney at the court before their first hearing. The defense attorney's job is to make sure the youth receives a fair hearing in front of the judge.
My role is to represent the youth in court. Part of what I do in representing the youth is to help him or her through the process, what is going to happen, what each stage of the process means, and also to represent the youth in court. I give advice on what might be the best choices or help the youth make choices as far as whether to go to trial, whether to take a prosecutor's offer for a plea of guilty, or to enter into some other disposition that might be available to them.
The defense attorney is there for the child. That was very difficult for me because I'm the mom. I was there for my child.
I watched defense attorneys come up to parents, and the parents were yelling and screaming and just out of control, mostly because their emotions were gone. And the defense attorneys just kind of turned them off and left. And I said, I don't want him to walk away from me. I want him to talk to me. So I stayed calm.
I had a great relationship with my son's attorney and his PO, you know, and like I said, that goes with communication. That's a two-way street. I mean, of course, if you show no interest, they're not going to show no interest.
You don't want to have any tension with your attorney because, like, you know, that just doesn't make anything better. You might not have, you know, it might make them not do as well of a job if you're just being rude to them all the time or cussing at them or anything like that.
We do have to keep a confidential relationship with the youth because that is our client. The law requires it, and the rules of ethics that we have to follow require that. So we will, from time to time, be meeting alone with the youth. It's not to try to keep the parent out, to push the parent out, but it's because we need to have some time with the youth alone because that's required of us.
That communication between you and your attorney could be the best thing for you. It could be the difference between you winning or losing a case.
The prosecuting attorney represents the state and is there to represent the state's interest in making sure that community members are safe.
Now, as prosecutors, we don't work directly with parents of respondents, but we do work closely with defense attorneys, and defense attorneys will meet with us to address what they feel is the best needs of the respondents. Now, we need to look at a lot of different factors when we're assessing what is the best result of the case. We need to look at community safety, the needs of the victim, but we also look at the needs of the respondent, and that can be a lot of different things. We work with the defense attorney, and we sometimes try to come to a resolution.
The judge listens to the prosecuting and defense attorneys, as well as any witnesses, including a probation counselor, child welfare worker, or parent, and makes the final decision about whether the youth is guilty and what they will have to do before they can finish the juvenile justice process.
The judge's responsibility in juvenile court is very similar to the responsibility that the judge has in any court, and that is to apply the law and uphold the Constitution, and also looking out for the best interests of the youth.
The Intake Juvenile Probation Counselor, or JPC, will meet with the family and youth while the youth is still involved in the court process. The Intake JPC will gather information from the youth, family, and possibly outside agencies like the school to complete a brief assessment of the youth. This assessment will help the Intake JPC make recommendations about services the youth could benefit from to the judge. The Intake JPC is a good person to talk to if you have questions about the juvenile justice process.
Youth that are referred to the juvenile justice system are automatically assigned to a juvenile probation officer. It doesn't mean that the youth is on probation. It just means that you're assigned to somebody to help guide you through the system, answer any questions, be a resource for community services or referrals. It's my job to make a recommendation. Ultimately, if the youth decides to plead guilty to anything, or if they're found guilty at trial of any kind of crime, the court gets a report from me, and that report basically is a summary of who the youth is, any treatment needs, any history regarding school, drugs and alcohol. Basically, it gives a summary of who you are to the court.
I think parents should be present when the child goes to see their probation officer.
I had a good relationship with my son's PO, and she was very, very helpful, very helpful. So I say my understanding came from her.
If the judge orders the youth onto probation, the youth will receive a different juvenile probation counselor. The JPC is responsible for working with the youth and the parents to encourage the youth to successfully complete all of the conditions given to them by the judge. The JPC will usually meet with the youth at least once a month, although this can vary, to go over their progress.
Once a person is put on probation, then the case is transferred to a supervision worker. I'm an intake probation counselor. I handle the cases all the way from the arraignment through disposition or sentencing. Once the disposition has happened, then I transfer the case to a supervision worker. Usually that's done within 3 days of disposition.
Before a judge decides what a youth must do to finish their process, the youth will first go through a series of meetings at the court called hearings. The hearings a youth may be involved in are called first appearance, second appearance, arraignment, case setting, plea disposition, fact-finding or trial, modification, and restitution. A youth and family will be notified about their first hearing either through a phone call from the detention screening unit or a letter from the office of the clerk. If a youth was placed in detention by the police, then they will have their first hearing the next court day, called a first appearance hearing. It is important to know that you may have to wait a few hours before you are seen by the judge on the day your hearing is scheduled.
The court process, it is a process. And so, first of all, you need to be prepared, even though they say to be there at 8:30 in the morning. Be prepared to spend several hours, which I wasn't really prepared for the first couple of times. Secondly, that the process takes many, many weeks. You come back several times, and I just wanted to get it over with. But I learned that it is definitely a process, and there is a reason for each step in the process.
If a youth does not appear for a hearing, a warrant may be issued, which could mean unnecessary time in detention. If a warrant is issued for a youth, it is best to contact their attorney.
I was there at every hearing. I'll never miss a hearing, you know. And I made sure he dressed. That's one of the things I did. He made sure he dressed appropriately, and I dressed appropriately.
First appearance is a hearing in the courtroom with the judge, attorneys, and the youth.
The first appearance hearing is not a full-blown trial. The judge doesn't hear from witnesses. The judge considers a short version of a police report and determines whether there's probable cause to believe that an offense was committed.
The youth may need to stay in detention if the judge is concerned that the youth may not come back to their next hearing or that they pose a threat to the community. Anytime the youth's detention status is reviewed, this hearing is known as a detention review. After this hearing, the prosecutor has to file the charges within a filing deadline. By law, certain offenses must go immediately to diversion. Diversion is a way for youth to handle their charges without going through the court process. You can ask the youth's attorney about whether diversion is an option in your case. Sometimes, when a youth is released from detention, they need to come back to a second appearance hearing to find out whether the prosecutor filed charges. The arraignment hearing is the time when the youth is officially notified of the charges being brought against them.
When the youth is being arraigned, what happens is that the charges are formally read. And the youth, who is now represented by an attorney, is asked whether they understand the charges, not whether they are guilty or innocent or whether they know all of the law, but in general whether they understand what they've been charged with, and they are required to answer in such a way that their answer can be recorded, and they enter a not guilty plea. Local practice is that no one enters a guilty plea at arraignment simply because the attorney doesn't know enough about the case at that point to enter a guilty plea.
Arraignments are sometimes in court and sometimes out of court, and it depends on what type of arraignment it is. So the defense attorney will let both the child and the parent know.
The case setting does not happen in a courtroom. Most often, the attorney will meet with the youth in the lobby of the court or in secured detention to discuss whether to change the plea to guilty and schedule a plea disposition hearing, or whether to continue to plead not guilty and schedule a trial. After discussing this with the youth, the defense attorney will inform the prosecutor about the plan.
Case setting hearings are always out of court in a lobby, and that's just because of the nature of the hearing. The only time we'd go into court is if there is some specific issue to address in front of the judge.
If a youth decides to go to trial, the judge will hear from all sides and any witnesses and make a decision about whether the youth is guilty or not guilty. The judge may decide at that point what the sentence or disposition will be, or another disposition hearing may be scheduled.
Now, in the event that the youth is found guilty and the matter will go to disposition of some sort, the parent becomes much more central to case resolution.
At the plea disposition hearing, the judge hears from all sides and any witnesses and provides a court order, which outlines what the youth must do and which will be monitored by a probation counselor or JPC. This could include confinement, community service, counseling, or other requirements.
And at disposition, the parent's role is often critical.
I would definitely be prepared to discuss any progress, not only at home but in school, how they're doing. If there's any successes, you really want to focus on those successes. At the same time, if you have concerns, if the child is still a danger to themselves or to those around them, that needs to be expressed because that's an important piece of the puzzle.
After receiving the court order, the youth needs to comply with the order to complete the juvenile justice process successfully. There are a few situations in which a youth may need to come back to court. If the youth does not follow their court order, their probation counselor may request a modification hearing. In a modification hearing, the youth will appear before a judge again, and the judge will decide what action to take based on the violation. The youth may also need to come back to court for a restitution hearing. Restitution means paying money back to the community for a crime that was committed. The juvenile justice process involves a lot of people and a lot of meetings and hearings. Ultimately, all of these different pieces are in place to try to make sure the youth receives a fair hearing and a fair sentence, but it may feel overwhelming at the time. Court staff, including intake probation and screening staff, are here to answer your questions and to help you get through the process.
Keep notes. I always have my pad.
Bring your book. And then if you got some thoughts on what kind of questions you might, write it down. Write it down. And don't be afraid to ask, because it's your kid life on the line here. It's not theirs or what. They just doing the job, getting paid. But ask the questions.
These people down here are not bad people. They've got a job to do. They're trying to do the best they can.
And that I think the court system as it stands right now is not perfect, but I really think they work the bent over backwards to make sure that it's a successful outcome for the child.
I really love the kids. I think that they have so much potential, and that if we can get them through this, that there is just no impossibilities for them.